Latavis Trashad Thornton. This is case 25-0203FY and may I have appearances for the record, please.
George and it on behalf of the people, Your Honor.
Thank you. And
I'm Melissa Vachon with the Office of the Public Defender. Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavis Treshad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton. So if you want to appeal,
please I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavis Treshad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But
yes,
there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton.
It may be rude, but it's true. Not to mention, they've already tried the whole calling him by the name his mother gave him routine, and that didn't work.
So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. No, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail, okay? So,
can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm
Okay,
fine with you doing most of it, but please, to protect my free speech, could you please not mute me? I have no intentions of.
All right, guys. Today we're diving into a case straight out of a legal drama. Christopher Moore, facing domestic violence charges, strolls into court thinking he can outmaneuver the system. But from the first few minutes, you'll see a man with no legal counsel, brimming with misplaced confidence. The judge tries to guide him, but Moore's attitude sets the tone for what's coming. Buckle up. This is just the beginning of a legal spiral you won't believe.
Like you said, come back and haunt me. I'm well aware of that fully Taylor Shot Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this and then I'll acknowledge you in just a minute. You haven't seen the evidence.
As we move into this part, Moore starts flexing that sovereign citizen logic. No lawyer, no strategy, just pseudo-legal jargon and courtroom bravado. The judge remains patient but firm, laying out Moore's rights and the serious risks he's taking. You can feel the tension rising. The stage is set for what's about to become a textbook example of how not to handle your day.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay, you can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety.
Now Moore is digging in deeper. Faced with new felony charges thanks to skipping court and making threatsies, still refusing counsel and clinging to his misguided legal beliefs, the judge calmly outlines the mounting consequences, but Moore just can't see the quicksand beneath him. This is the turning point where a simple case unravels into something much bigger.
It does not profit, and so with that information, I understand that the script goes a little different, and I understand that I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry, and
okay. All right.
Yes,
So
ma'am.
here's
Your Honor.
here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago. And he said, and he really upset people with this, he said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law. But a person does not become an LLC. But regardless, I'm going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now
We're now at the hearing. That seals Moore's fate. Surveillance footage surfaces crucial evidence against him. Moore's bravado fades as reality hits, but it's too late to pivot. The court lays out the weight of the new evidence and the steep legal trouble he's now in. Watching this unfold, it's clear. A little courtroom humility would have gone a long way.
you have the right to an attorney, and today Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses. And if they didn't want to appear, the court could issue a subpoena, and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right.
Things are spiraling fast. With the bond now revoked and new felony charges stacked, Moore faces the harsh consequences of his earlier defiance. The judge holds firm, making it clear this is no longer just about domestic violence now, it's about public safety and court integrity. You can almost feel the gravity settle in the room.